Thank you for coming this evening to the California Initiative Forum. We're very pleased to see so many people come out to be educated and have a discussion with us about the 17 ballot measures that will be on the November 8th ballot. And I know it is comical just to say it out loud, 17 ballot initiatives. Because we have so many and because we have only 2 hours, I want to get started right away. Please feel free, though, to get some refreshments. It's going to be a long haul. If you need refreshments during the forum, feel free to get up and revitalize yourself. It's hard work, and we appreciate that you're here, and please do enjoy. Two things. First of all, welcome to McGeorge. This is a forum that is presented by our Capital Center for Law and Policy here at University of the Pacific, McGeorge School of Law. I do want to announce an event that's happening through the Capital Center on Friday. It's an executive training, and the topic is Persuading Legislative and Administrative Law Audiences. It will be featuring Professor Jay Leach and Rex Frazier, who's an adjunct professor here. It's this coming Friday from 8:30 to noon with breakfast provided. And it's going to be, I believe, in the courtroom, which is right across the street from this building. If you have not signed up already, it's not too late. It would be great if you can RSVP, even if you want to show up the day of the event. You're welcome to join us for that. So you can find that information on the McGeorge website. Speaking of the McGeorge website, excellent segue to the fact that we apparently are out of our hard copies of the California Initiative Review and the California Initiatives at a Glance. If you did not get a copy of either the full and complete reports or of the Initiative at a Glance, you can find them on the McGeorge website. From the home page, you should see a link to the Capital Center, and the link to either the Initiatives at the Glance or the full reports is there on the homepage. So thank you very much for coming. We want to make sure that you get the information, and I'm going to also give a shout out. We are live streaming. Oh, apparently we have found more initiative reviews. Woohoo! There were many boxes underneath the table, hiding in plain view. Okay, so if you did not get one, you still can, and that's great. We're live streaming this event this evening as well, and so a shout out to everyone who's watching at home. I'm sure there are many. I think maybe my mom is, so hi, Mom. Okay. I should introduce myself. I'm Mary Beth Moylan. I teach the California Initiative Seminar here at McGeorge. The students who are going to be presenting tonight are the 22 students who are enrolled in the California Initiative Seminar. They have been studying the initiative process all semester. They have worked hard to analyze each and every one of the ballot initiatives for their own benefit and for yours. I'm going to try to quickly get to them, but a word about how we're going to do the questions this evening. So I thought I had the little, okay. So you know that you're at the California Initiative Review. Here's our agenda for the evening. We have grouped the 17 propositions in groups of mostly 2. There's one group of 3. We've grouped them topically. This is how we're going to cover them tonight. So we'll have the 2 relating to education go first, Proposition 51 and Proposition 58. Then we'll take questions on those. Next we'll move to public safety. Propositions 57 and Proposition 63, take questions on those. You get the idea, right? And until we get to the final grouping, which I am calling adult recreation. Thank you very much. I came up with that all by myself. Okay. And then we'll take final questions on that topic. So we have passed out cards. If you did not get a card, some of the students will come around and bring you a card. We'd like you to write your questions on a card, and then we will ask the questions and direct any duplicative questions to the right people. So, and there are some people who want, okay, good. Keep raising hands until you get what you need. That's my motto. Okay, so without further ado, we're going to have the students come up and talk to you about each of the initiatives. We'll break in between each section to take some brief questions, and we're going to try to get through all of these in our 2-hour time frame. So the first group will be on Proposition 51 and Proposition 58. Proposition 51 was written by Maral Farsi, and Proposition 58 is Jamie Taylor and Lily Udang. And so Maral is going to start us off, and then Lily and Jamie will take it from her. Then I'll come back with the questions. Sound like a plan? Let's go. All right.
Woo! Hi, everybody. There's a lot of people here. I just got nervous. Proposition 51 is on school facilities and community college bonds for improvements and modernization. It would allot $9 billion for funding for K through 12, charter schools and technical schools, and community colleges. The need for this bond, as has been stated by the supporters, is that there hasn't been a bond to fund school funding since 2006. And the statewide funding ended, it was depleted in 2012. However, local entities, local school districts, counties, et cetera, are able to pass local school bonds and are eligible to receive matching funds from the state. And those matching funds essentially don't exist. So localities are passing these bonds without any matching funds. The other bonds that have been passed since 1998 on school facilities funding total $45 billion. So that, again, that $45 billion is now depleted. This bond would amount to $9 billion, but the interest payments are going to amount to $8.6 billion, meaning that there is going to be a $17.6 billion bill for the state of California over 35 years. Excuse me. So the proponents of this measure say that there is a backlog, and because there hasn't been any new funding provided for this measure or for this issue, and you know, the parties that support it are both the Democratic and Republican parties. The Superintendent of California supports it. The Lieutenant Governor of California supports it. A long, long list of school districts and elected officials support it. And the funding on the Yes campaign has been entirely by developers and construction companies. The no's for this, there's no campaign funding, there's no opposition being run, but there's a significant vocal opposition by California's governor, who doesn't want to do any unnecessary spending, and some taxpayer organizations. I will complete by saying that in our quick guide there was a little typo at the bottom where there's a reference to Proposition 47. That should be Proposition 51, and I will end right there. Thank you.
Good evening. My name is Liliana Udang, and I, along with my partner Jamie Taylor, worked on Proposition 58, which you see up behind you. A couple of quick things about Proposition 58. What it does is it essentially repeals the English-only mandate on public school education and replaces it with options for school districts to come up with their own bilingual immersion programs if they find that there is both a need and a desire for those programs. Additionally, this is the only legislatively referred, as you can see behind me, initiative on the ballot this year. That means it did not have to get a petition sent to the Attorney General, no signatures needed to be requested. To get it on the ballot, it simply had to go through the normal legislative process. Went through both houses, was signed by the governor, and now it's on the ballot for you all to decide. One other highlight, I want to flag for you all tonight is the drafting of the majority vote for amends. Initially, Proposition 227, which is the English-only mandate, required that the legislature could only amend in furtherance of the purpose of English-only education by a 2/3 majority vote. What Proposition 58 is entailing is that you have to only have a majority vote in the legislature to amend. And it's no longer in furtherance of, it is for any purpose. So you could amend or repeal through the legislature by a simple 41 votes in the Assembly and 21 votes in the Senate. Finally, another drafting issue to flag for you all is the application mechanism. 30 students per school or 20 students per grade. If those parents of that cohort of students wishes to have an immersion program in their schools, all they have to do is request one from their school district. The school district then goes and gets a grouping together of stakeholders within the community, including parents, teachers, administrative assistants, other major figures in the community, and with that entire cohort, they determine whether or not an immersion program is probable or needed in the community. I would like to emphasize, though, that none of these programs are mandatory. This is all optional for every single school district that chooses to adopt some sort of immersion program. And so what I'm going to do now is hand it over to my partner, Jamie Taylor, and he's going to go over the proponent and the opponent arguments, and then give you just a little bit of a spiel on what a yes vote would mean and what a no vote would mean.
Thank you, Lee. So the supporters of Proposition 58 include the California Democratic Party, the Peace and Freedom Party, Secretary of State Alex Padilla, State Superintendent of Public Instruction Tom Torlakson, Lieutenant Governor Gavin Newsom, Governor Jerry Brown, other elected officials, statewide Democratic state officials, and mayors. The expenditures thus far for Prop 58 has been about $1 million. In the opponent's side, they have spent $0, and they include the California Republican Party, the California Libertarian Party, Ron Unz, and an organization by the name of Keep English for the Children. The proponents argue the following, that bilingual education does better for English proficiency and long-term assessments. When Proposition 227 passed in 1998, there was an immediate spike in the test scores towards English proficiency. It validated Proposition 227. But what researchers are now starting to find, and this is also from a regional standpoint, because for the most part, schools are English only. They're taught in sheltered English. But where there are bilingual programs, where vouchers have been approved, such as San Francisco Unified School District, researchers from Stanford University have done a very extensive long-term evaluation of test scores and seen that over the long period of time, bilingual education students learn at the same rate in the long term. Not immediately, because it takes a certain period of time toward English proficiency, but over the long period of time, they are at the same level. But what they do have, the language bonus by learning bilingual education as opposed to monolingual education or English only, is that not only do they learn English proficiency better, they also learn their native language better, which has a positive impact both cognitively in terms of their executive function, the way their brain works and sorts information, code switches, and has to evaluate decisions to make. Do I answer in English? Do I answer in Cantonese? Do I answer in Spanish? Do I answer in Russian? And what that does is that helps with trying to figure out how to decide and how to organize your thinking process, so that there's a cognitive bump as well as there are benefits to the economy. If you speak both languages or multiple languages and can do business, you are that much more appealing to a potential employer. So those are some of the proponents' arguments. Also, it provides for local control. Back in 2013, the Governor Brown signed into effect local control financing formula, or local LCFF and the LCAP, which actually what it does is it focuses all budgetary priorities on local prioritization for education for students who are at risk of failing. And so those that are vulnerable happen to be at the lowest are English learners. 24% of our dropout rate is attributed to that population. And so this helps innovation at the local level, and it supports accountability at the local level. Opponents believe that English is taught better and learned better in English. Prior to 1998, the feeling at that time was that bilingual students were being marginalized. They were being placed in dumping grounds. Schools were receiving more money for their funding because they were a harder to teach population. And so they were over there and they were not matriculating back in or being reclassified back into the regular classroom. And so that was sort of the sentiment at the time. Both Ron Unz and many others felt that and showed and demonstrated that increase in the test scores immediately after, as well as they demonstrate 15 years later that more students are, Latino students in fact, are being accepted into the UCs. Ron Unz attributes that directly to the English-only efforts of Proposition 227. So there's those issues are both on the proponent side and the opponent side. Just to remind you that a yes vote means that you would want to repeal English-only education and replace it with options for school districts to choose from local innovative efforts. And a no vote means that you want to retain Proposition 227's English-only education mandate. Thank you.
Okay. People have cards, question cards for 51 or 58. And no, Meral, you go up. You go there, and I'll go here. Okay. Great, thank you. You got some? Those are extras. Anybody else have some? Jess can get them over there. Okay. 51, 58. Got one more coming in. Do you have one? No. Okay. Will you go get it? Okay. Okay, let's start with Proposition 51. Do public schools and charter schools share equally in the Facilities Bond Act proceeds? And if so, why?
I assume you're talking about the funding, and the funding is actually, if you look at the quick guide, it's broken out. I believe that it's $3 billion for K through 12. Somebody's got their voter guide open, let me know if I'm wrong. $2 billion for community colleges. And I think there's another $3 billion for charter schools and technical, and it's split somehow. I'm wrong, probably. $1 billion, sorry. It adds up to 9 somehow. I'm missing 2. But it's not equal.
Okay, now we have 3 questions for Prop 58. The first one is, will it undermine the 2/3 vote rule? And I'm assuming the concern is, the 2/3 vote rule. And so I think you did mention yes.
Yes, so Proposition 227 required a 2/3 vote majority to amend. If you vote yes on Proposition 58, you will also be taking out the 2/3 vote majority and replacing it with a simple majority vote to amend the education process in terms of language.
And the next 2 questions I'm going to ask together. First, what would be the cost of implementing it, and where would the funding come from? And actually hold that thought. And also, if a student requests bilingual education, if the parents request the program from the school they attend, is the school required to offer the program? So why don't you take those 2 together?
Sure. So to the first part, for spending, it all comes down to an individual school district. If the school district already has the funds and the means to incorporate this sort of program, there will be no additional costs to the state. Additionally, as Jamie had mentioned, the LCFF plan, which grants the schools their money, and kind of in the LCAP, which explains how you must prioritize that money, the school districts themselves get to choose where their priorities are, as long as they don't go against the state's priorities. So that means the school at the beginning of the year will be able to determine if they need the money for this, and no additional funds will go to that. As to the second question, the mechanism to ask for a program requires that 30 students in a school or 20 students per grade have their guardians seek this. That does not mean that the school must incorporate a bilingual program. It just means they now have an incentive to go and talk to their stakeholders to create one that would suit the school's needs.
Okay, thank you, guys. Okay, next we have, I'm going to switch. Next we have our public safety category, and our first up for public safety, who took the clicker? Oh, it's over there. First up for public safety is Proposition 57, and our writers for that are Navneet Bandal and Tessa Navarez, and then we'll be having Proposition 63, and that's Casey Souza and Stella Huynh, and I will get the... Oh, there you go. Okay. I'm going to leave this here. Don't touch it.
Okay, we won't. Hi, everyone. Can everyone hear me okay? No? Is that better? Okay, I'll lean in a little. So Tessa and I are going to talk to you about Proposition 57, also known as the Public Safety and Rehabilitation Act of 2016. This is Governor Brown's baby. I'm going to talk to you about why the proposition is needed and what it does. And Tessa's going to talk to you about the proponents and opponents' arguments. In 2011, the Supreme Court held in Brown v. Plata that California state prisons were so overcrowded that they violated the Eighth Amendment's prohibition against cruel and unusual punishment. The federal government ordered that we as a state reduce our prison population. So they gave us a couple years to do that, and Governor Brown is using Proposition 57 to reduce our prison population and to comply with this federal mandate. Proposition 57 essentially does three things. First, it makes inmates convicted of nonviolent felonies eligible for early parole. The key word here is eligible. Proposition 57 does not guarantee early parole. Inmates still have to go before a parole board, and the parole board will make the ultimate decision. Second, Proposition 57 orders the Department of Corrections and Rehabilitation to set up rehabilitation programs to rehabilitate inmates and to ensure that these programs will not pose a danger to public safety. The proposition itself does not outline a rehabilitation plan. Lastly, Proposition 57 gives judges in juvenile courts the authority to decide whether a juvenile should be tried as an adult or as a minor. It takes powers away from the district attorneys who currently have this authority. Now I'm going to hand it over to Tessa.
Hello, I'm going to talk about the policy considerations for Prop 57. So the proponents' main arguments are first, that it will reduce the problem of prison overcrowding, and second, that it will save the state money in incarceration costs. This is likely true. The LAO estimates that there are currently 30,000 inmates. Sorry. Hi. The LAO currently estimates that there are 30,000 inmates who would be eligible for release upon the passage of Prop 57, and also the state will save tens of millions of dollars annually if Prop 57 is passed. Next, proponents also argue that Prop 57's emphasis on rehabilitation will save incarceration costs and prevent crime into the future. Prop 57 includes sentence credits for educational and other achievements, and research by the DOJ shows that inmates who participate in educational programs while in prison reduce their chances of recidivism by up to 43%. So moving to the opponent's arguments, they argue that Prop 57 is poorly drafted and that as a result, violent criminals will be released into society. It's true that nonviolent felony isn't defined in Prop 57 because it's broadly drafted, and so opponents argue that this means that every crime that isn't explicitly listed as a violent felony will be included. But this isn't necessarily true. The CDCR still has the authority to set specific standards, and they have to enhance public safety with these standards and include public comment in this process. And additionally, the Board of Parole hearings still maintains the ultimate discretion as to whether an inmate is fit for release into society. And lastly, opponents argue that Prop 57 overturns measures enacted by voters, such as the 3 strikes law. Prop 57 doesn't actually directly affect the 3 strikes law on enhanced sentencing requirements, but it does take the teeth out of it somewhat because non-violent felons will be considered for parole release after completing the full primary sentence without sentence enhancements. Okay, and that's all for Prop 57. Thanks.
Hi, can everyone hear me? Oh. Can everyone hear me okay? We're here. Oh, do I need to click it? Hi, my name is Casey Souza, and myself and my partner Stella Wynn are here to talk to you about Proposition 63, also known as the Safety for All Act of 2016. This proposition is, its proponent is Gavin Newsom. This one's one of his babies that he put forward on the ballot. He's looking to, and the measure is looking to lower the number of lives lost from the wave of recent gun violence in our country. It notes that gun violence can have a big cost on the economy, and so this proposition seeks to keep guns out of the hands of those that should not have them, while still protecting the rights of law-abiding citizens. Okay. So there are 3 main things I want to highlight that this proposition does. The first one I want to highlight is that this proposition will ban all possession of any high-capacity magazines except for those in law enforcement. The law as it stands currently allows those who had them prior to the year 2000 to keep them. However, this proposition makes it so that even those people must give up their large-capacity magazines by either taking them out of the state, selling them, or handing them over to law enforcement. The second thing I want to point out that it does is that this proposition does create a new court order to ensure that those who are not allowed to have firearms and ammunition don't have them. This is the part of the proposition that would potentially have a lot of new costs involved as the proposition seeks to have new probation officers and others ensuring that those who are not allowed to have firearms no longer have them. The third thing Proposition 63 does that I want to point out is that it states background checks for ammunition. To have such a permit, one must apply through the Department of Justice and pay a $50 authorization fee. There is a conflict here I want to point out, however, with a bill called SB 1235, which was passed over the summer. In that bill, it says that if Proposition 63 were to pass, one of its provisions relating to background checks for ammunition would actually not become active. And the provisions in SB 1235 relating to background checks for ammunition, which don't involve getting a permit, but rather involve each person being checked each time they buy ammunition, would instead be active there. And with that, I'm going to pass it off to my partner, Stella.
So I'm going to talk about the proponents and opponents argument for Prop 63. So yes on 63, Prop 63 proponents argue that Prop 63 will keep guns and ammunition out of the wrong hands, which Casey alluded to earlier. And the main motivation behind Gavin Newsom and the prop is to prevent, is the kind of the mass shootings that occurred in the past several years. And so Prop 63 is supposed to keep the guns and ammunition out of the wrong hands and criminals from getting guns and ammunition. Proponents also argue that the initiative closes gaps and loopholes in existing laws and that it goes beyond the gun control laws that were passed this past summer. And the proponents also argue that the rights of law-abiding citizens will still be protected, so everyone can still keep their guns. So. No on 63. Opponents on Prop 63 claims that it burdens law-abiding gun owners because of the additional and increased costs, like for court processing and administrative costs to apply for permits and things. Also, law enforcement is actually against Prop 63 because they claim that increased court costs and increased law enforcement costs, or it diverts their resources to court costs that would be used for Prop 63 instead. And they argue that instead of using the costs from that, their resources could be used to enforce existing laws. Opponents also claim that the initiative does not keep criminals and terrorists from obtaining guns. They can still get it regardless of whether other laws are enacted. And that's it. Thank you.
Okay, questions for 57 or 63? I have one down here while others are being collected. I need 57 up here, thank you. Okay, so I'm going to read this question. Keep in mind, I did not write it. Isn't it true that if someone had committed 2 prior murders and then committed a rape of an intoxicated woman, he would be considered a nonviolent offender under Prop 57 for the final crime committed? You want to do this one?
Yeah. I'm assuming you mean if someone had committed a murder in their past and already served their full sentence and been released for that crime, and now they are arrested for a nonviolent felony, yes, they would be eligible for release after the primary sentence for that nonviolent felony.
If they committed 2 murders.
If they managed to serve the full
Sir,
term,
if the answer is, if they have served their full term, they would still have to serve their term for the new offense, and they would then be eligible for release, but not necessarily released, because I think as both Navneet and Tessa indicated, for Prop 57, they still need to go through the parole board. The prior strikes would be considered by the parole board, correct? Yes. So,
But the point of the question is rape of an intoxicated woman is considered nonviolent by Gary Brown.
the nonviolent felonies are not defined by the proposition. They're not defined. Okay, next. Thank you. Okay, can you give some examples of the types of nonviolent felonies that might allow early release?
Rape of an intoxicated woman. That's what Rob Turner did, and he would be nonviolent under Prop 57.
Sir, thank you. Sir, we're going to let the students respond to the questions, and if you are not willing to do that, we'd ask you to please leave. Thank you. Okay, is there funding to support inmates' programs for education while incarcerated? This is a 57 question as well.
Proposition 57 does not provide any funding.
Okay, now for 63. Does 63 provide any funding, and where does the funding for Prop 63 come from? For example, the new court process.
They're mostly going to come from the application process, and the money that you pay to get the permits is going to go and offset the cost. It's supposed to offset the cost. Yeah.
And actually, the initial funding is going to come from a $25 million loan from the general fund, and then that loan is going to be paid back, and then the future of the program will be implemented by these fees that come from applying for the ammunition purchase authorizations, the background checks.
Would you guys stand up there so we don't have to keep passing the mics. For Proposition 63, will law enforcement officers be able to have magazines for personal use?
For personal use, I don't believe so. I'm actually not quite sure about that one, but I believe, yes, it does have to be in the line of their work for them to still have them.
And also, can you clarify who needs the $50 card? Every ammo buyer? Who will need to, yes.
Yes, every person seeking to purchase or transfer ammunition would need that. It's called an ammunition purchase authorization, so.
Okay, back to, nope, staying with 63. Didn't the governor just sign a bill banning magazines with a capacity above 10 rounds this past legislative session?
Yes, yeah, he did.
No, we already answered that, didn't we? Okay. Oh, I like this one, actually. This is the one I wanted. Okay, this is Prop 57. How difficult is the single subject issue for Prop 57? So for those of you, brief classroom time, we have a single subject rule. It says that no measure put before the voters shall embrace more than one subject. As you've heard here a couple of times tonight, this proposition does 3 things, this proposition does 4 things. How does that pass the single subject rule? 57?
Well, the two subjects of the proposition have to be reasonably germane to one another, and they both have the goal of reducing prison population. And so changing the prosecutorial discretion to having the judges have discretion over juveniles would reduce the prison of adult courts of juveniles. And then also having early release of inmates would also reduce prison populations, so those both are reasonably germane to each other.
Okay, I'm not sure I understand this one, so I'm going to pass. This is for Prop 63. What is the standard for a pass or fail on a background check?
The background checks will cross-check with, I believe, the mental health system and one other thing that I can't remember at this moment, but they'll look to such organizations as that to see if there's any reason that you should not have firearms or ammunition. Do you want to add anything?
It's the national criminal, yeah, it's like the federal one, the national criminal, it's an acronym, NC.
Instant background check or something,
like
yeah,
that.
so.
Okay, thank you. Final question for 57, then we're going to let you all off the hook. Regarding removing charging decisions from the district attorney, can you explain that more?
So prior to Proposition 21 in 2000, district attorneys had to file something with the juvenile court asking for a hearing for the juvenile to be tried as an adult. And with Proposition 21 in 2000, that was taken away, and district attorneys were given the opportunity to directly charge the juveniles as adults. And so what this proposition will do is that it'll give the discretion back to the judges, and the judges will be able to consider past crimes, family life, the juvenile's psychological ability, and stuff like that.
Thank you all very much. Okay, we're moving on now to governance, and we're going to have Proposition 54, which was written by Rachel Simons and Brian Russ, and then we'll have Proposition 59, and that's Brian Perino and Anam Hassan. So, Prop 54.
Hi, everyone. So Prop 54 is called the California Legislature Transparency Act, And as that title suggests, it's aimed at providing greater transparency in the California legislature, and it proposes to do this in 3 ways. So first, currently the legislature utilizes a process known as gut and amend, which is mostly used in the last few days of session. Gut and amend means that they'll take a bill that has stalled for some reason in the legislature, they'll completely gut it of all of its language, and they'll put brand new language into it. This means that the new bill maintains its current status in the legislative process and that it can be voted on almost instantaneously. So sometimes before legislators, let alone the public, have had a chance to read the language. While the legislature does have House rules that usually prevent such rush procedure, these rules are waivable by a simple majority vote. And this proposition seeks to eliminate this process by setting a requirement that the final version of any bill be posted online and available to the public for 72 hours prior to any vote being taken. The proposition also has an emergency exception as declared by the governor, where a bill can be passed by 2/3 vote in each house without the 72-hour wait period. Second, currently most of the public hearings and sessions are recorded and broadcast by the legislature for the public to watch, and some are archived on the legislature's website. This proposition will ensure that all public sessions are recorded and that these recordings are available online within 24 hours of the end of that session, and that these are maintained online for no less than 20 years. And third, currently the public is prohibited from making their own recordings of any public session of the legislature. This proposition would allow the public to make their own recordings and be able to use those recordings or the legislature's recordings for any legitimate purpose. And my partner Brian will go over the arguments for support and opposition and the funding.
So the proponents of Proposition 54 argue that this would allow more transparency in the legislature's proceedings. By having a 72-hour mandatory waiting period, it would allow the public to be more informed about what is going on and what the legislature is voting on. And it would also allow the legislature more time to know what they are voting on. They argue instead of waiting sometimes less than an hour between a bill is published and voted on, it would give a mandatory waiting period, except for emergency situations. Also, the goal of having more transparency would be aided by allowing the recordings of all public sessions of the legislature by posting them online and archiving them for 20 years. Currently, only some of the sessions are recorded, and there's no mandatory minimum archival requirement. The proponents argue that by allowing anybody to also, the public to attend these sessions and to make recordings and then to use these recordings for any legitimate purpose, it furthers this ideal of transparency and knowledge, essentially, of allowing the people to know the people's business. The opponents argue that this is just an attempt to allow special interests to derail important negotiations of the legislature. By giving this 72-hour minimum waiting period, it allows opponents of the bills to organize opposition to the bills and to kill deals that the legislature has worked on. And so, and again, also with the recordings, currently the use of recordings is limited by statute. So by allowing these recordings to be used by the public, it would increase political attack ads. So the ads you see on TV and so on, it would just encourage people to use these ads for nefarious purposes. The proponents, organizations supporting Proposition 54 include the California Chamber of Commerce and Common Cause, and the largest organization opposing Proposition 54 is the California Democratic Party. The funding, the proponents, Yes on 54 has been funded solely by one person, Charles T. Munger Jr. He's put $9 million of his own money into the campaign, and the opposition to Prop 54 has raised $0. So there's a disparity there as well. So in sum, the folks who say yes on 54 say that it leads to more transparency and more time to understand what the legislature is voting on. And the opponents of Proposition 54 say that we should trust the legislature to do their business the way they see fit.
Thank you, everyone.
Hello, everyone. Again, my name is Anam Hassan. Today I will be sharing two important things that you should know about Proposition 59, and my colleague Brian will be going into proponents and opponents' arguments. Thank you for that. In the form of an advisory measure, Proposition 55 is a declaration telling Congress to pass an amendment to overturn Supreme Court decision Citizens United. Citizens United lets corporations use their treasury funds as independent expenditures in the form of First Amendment protected speech to support or oppose political candidates. Before Citizens United, corporations could only use political action committees, or most commonly known as PACs. To do so, now they can use independent expenditures.
So the proponents of Prop 59, they argue that the Supreme Court was wrong when it decided Citizens United. And they feel that this issue is so fundamental that it is important to have, necessary to have a voter instruction, so that way they can accurately gauge their constituents and decide whether they actually support overturning Citizens United or not. And also with the constitutional amendment, it ensures that the Supreme Court in the future can't change their interpretation of it. They'd have to comply with that amendment. Now, the opponents of Proposition 59 say that it's advisory only. It actually creates no legal obligation on any elected official, so they could vote essentially any way they want to if that constitutional amendment comes, no matter what people vote on this proposition. And the LA Times indicated that they would be against this proposition because the proposition doesn't actually say what the constitutional amendment would be. And so they believe that the Supreme Court should be above politics. And so a yes vote would mean that you support the Congress initiating the constitutional amendment process to offer an amendment to overturn Citizens United.
Thank you.
Okay, stay. No, stay. Hello. I know I'm stay up. Questions about 54 or 59? We have a couple over here. Maral, why don't you bring me those so I can get started? No time to waste, no time to waste. Okay, oh, thank you, wow, okay. All right. Okay, would there be any threat to security, thank you, or possibility of potential lawsuits resulting from passing Prop 54?
There's always the possibility of a lawsuit. Somebody could get really excited and want to do, cause some problems. I think one of the biggest problems in it is that it allows the recordings to be used, and it says for any legitimate purpose. As you know, the First Amendment of the Constitution says that freedom of speech shall not be abridged. So by passing Prop 54 and allowing recordings to only be used for legitimate purposes, we don't know what a legitimate purpose is. Nothing in Prop 54 says what a legitimate purpose is. And so there could be some litigation there.
Staying with 54. Don't go too far, Brian. Does Munger have a business interest? Otherwise, $9 million seems like a foolish investment. I like that one. That's good.
So Mr. Munger is he's a physicist. I don't believe he has any business interest in it. He has funded many other proposition campaigns of multi-million dollars as well. He's a billionaire. He says that he wants to do it for the benefit of the public. So.
And sticking with 54, what is the cost of filming and storing 20 years of hearings, and where is the funding coming from?
So the Legislative Analyst Office, they predict that it's going to be an initial $1 million to $2 million for getting more cameras and getting more storage online. But all of this will be absorbed into the legislature's current budget, which comes from the general fund. And then each year it will be about $1 million for maintenance.
And we have a couple of questions about the timing, the 72-hour waiting period. One question is 72 hours enough to ensure that the public will have notice? One is, what will trigger the 72-hour waiting period? And one is, what are the kinds of emergencies that will that will allow for them not to use the 72-hour waiting period?
So the language doesn't address what an actual emergency is. It's as declared by the governor, and I know that there's parameters for what he is allowed to declare an actual state emergency. So it just goes under that umbrella. What was the other question?
I have no idea.
If 72 hours is enough, and when does it start running?
Oh, what triggers it? It doesn't speak directly to that, but I would assume once it's been amended and it goes across the desk in each house, then that means that that version is available. So then I would assume that that's when it would go up online on LegInfo.
And is 72 hours enough time for public notice?
I mean, you guys tell me.
It's better than what we have now.
That's true.
Okay. We had a lot of people wanted to know what constituted an emergency, so you see me flipping through these all because we already asked it. Okay, let's give Prop 59 a chance. How common is it for the legislature to seek advisory opinions from the voters? Seems odd.
Actually, yes, it is a little odd. The legislature would take the position that they've always had this power, and actually this issue was litigated in 2014. The last time the legislature actually did an advisory opinion, it was in 1936. And the court said that because this related to their investigatory powers under Article 5 of the Constitution, that this advisory question is warranted. So there's kind of debate on how many advisory questions could be in the future. Because it's a constitutional issue, this one definitely qualifies. In the future, that kind of issue is still most likely going to be litigated again if it doesn't relate to the federal constitutional amendment process.
Okay, and last one for 54, and I really like this question, so I know you know the answer. Here we go. Would the legislature's constitutional right to adopt its own rules supersede this effort to change the rules? I love that one. Okay.
So the only part that affects the legislature's ability to make its own rules was included as an initiative constitutional amendment, which is the way that the people are allowed to do this kind of thing. So this proposition goes about it in the right way. The parts that are statutorily changing things only address the recording and disseminating of videos. So this is all good.
They did it right. A+ for
They
Rachel. Okay, good job. Okay, we are moving on to death. I know that's profound, isn't it? We really are. There's no option. Okay. Sorry, a little levity with the death penalty initiatives. Proposition 62, I know. Proposition 62, we have Veronica Bravo and Jess Gosney, and Proposition 66, we have Christine Mahakian and Samantha Huynh. So they're going to talk to you now. It's not a light slide either.
Hi, my name is Jessica Gosney. This is my partner, Veronica Bravo. We are going to talk about Prop 62, officially known as the Justice That Works Act, commonly known as death penalty repeal. Prop 62 does three things. First, it repeals the death penalty for first-degree murder. It converts all of those sentences into life imprisonment without the possibility of parole. And it requires that those individuals work and pay 60% of their wages to restitution. The Legislative Analyst's Office believes that this will save the state $150 million per year. There's a few interesting drafting questions that are posed by this proposition. You can read all of them in our long version, but there's two that we want to flag for you. The first one is that it only repeals the death penalty for first-degree murder. There's actually 5 other ways that an individual in California could be sentenced to death. One of them is train wrecking. You can read about all of them in there, but I bring up train wrecking because this is not necessarily a moot point. While it's unclear how many of the 748 individuals currently sentenced to death in California were in prison for something beyond first-degree murder, in 2005, the LA District Attorney's Office did charge Juan Alvarez with train wrecking and requested the death penalty. He was ultimately sentenced to life in prison without parole, but the fact that it's still being used as a capital murder punishment, that these other ways that people are being sentenced to death in California, does warrant consideration. Secondly, as our partners who talked about, we'll talk about in Prop 66, there are two competing measures on the death penalty on this ballot. And one interesting fact about them is that if they both pass, the courts will have to look to severability and to see what happens if you have two propositions that pass. Prop 62, the 60% restitution clause, could possibly be severed because the proposition requires that only for murder. It doesn't specify first-degree murder, so people sentenced to second-degree murder could still have to pay that 60% restitution in the proposition.
Thank you, Jess. Good evening. The main argument of Proposition 62 is that the death penalty is very costly, inefficient, and lengthy. Both Proposition 62 and 66 agree on the inefficiency and high cost of the appeal process, but whereas 62 seeks to abolish the death penalty, Proposition 66 seeks to reform it. So there is not a lot of documentation on just how much the process involving the death penalty costs, but the Legislative Analyst's Office estimates currently the cost per death row inmate to be about $300 million from time of sentencing to execution, and estimates approximately $55 million in just court costs. The LAO estimates a total savings of approximately $150 million annually if the death penalty is to be abolished. The court process for the death penalty is lengthy, costly, and takes approximately 20 years. Reasons for this is that there are separate trials for death penalty sentencing, and there are direct appeals or automatic appeals for persons sentenced to death, in addition to the habeas corpus petitions. Also, death row jails are more expensive because they require more supervision and separate jail cells. Investigators are hired for both sides, prosecution and defense, during trials. Jury selection is longer because people do not believe in the death penalty, do not want to serve as jurors. Appointed defense attorneys waive out as counsel because they don't want to take on cases that are too expensive and lengthy. So overall, it is difficult to estimate exactly the fiscal savings because these would depend on several factors, like how many people would have gotten the death penalty, and we do not know how the courts will handle resentencing. So supporters of Proposition 62 believe it will eliminate the possibility of executing an innocent person and that it will save money. The opposition believe that the worst of murderers deserve the death penalty and that it brings closure to victims. As far as public policy issues, several studies have found that the death penalty court process is unfair and racially biased. In a recent study conducted by Harvard Law School, they found inadequate defense lawyering, racial disparity in sentencing, and for example, in Riverside County, they found that 76% of defendants sentenced to death between 2010 and 2015 were people of color. Also, too many individuals with mental illness are being sentenced to death. Thank you.
Hi, everybody. Can you hear me? Okay, good. Hi, my name is Christine, and my partner is Samantha, and we're going to talk to you about Proposition 66, which is also known as the Death Penalty Reform and Savings Act of 2016. So the purpose of this initiative is to expedite the death penalty legal process, and it does this by doing 6 reforms to the current process. The first would be a change in the avenues of legal challenges for appeals. So basically, there are 2 ways to appeal a death sentence, and they're known as habeas corpus and direct appeals. And these are automatically appealed to the California Supreme Court. So Proposition 66 would change this a bit by requiring habeas corpus petitions to first be heard in the trial court where the case took place. And with the judge who presided, he would review the habeas corpus petition.
and direct appeals would still be heard through a California Supreme Court. And any pending habeas corpus petitions would be transferred to the trial court if this proposition were to pass. The second change would require a time frame for review and decisions of appeals. So currently, it takes the California Supreme Court up to 25 years to review and decide on a death penalty case. So this Proposition 66 would require completion of habeas corpus and direct appeal to be reviewed and decided within a 5-year period. It would apply to new legal challenges and those currently pending in the courts. If the process were to take longer than 5 years, victims and their attorneys could request a court order to address the delay. The third change would be through the process of appointing attorneys. It would require the trial courts to appoint attorneys to represent inmates in their appeals for the death sentence. And then the fourth change would be through the inmate housing for death row inmates. So currently, prisoners on death row are in a single cell and often handcuffed at all times when escorted by one or more security. This proposition would change this by allowing any state prison to house the death row inmate. It would also exclude, Proposition 66 would also exclude California Department of Corrections from APA review on death penalty methods of execution. And finally, it would require labor from the inmates, and this would not include physical fitness. And any restitution that is owed to victims, they would take out 70% of their wages from the inmates' work.
So I'm going to talk about the issues and the proponents and opponent arguments. So one of the significant issues of Proposition 66 is that it's going to, as Christine mentioned, that it's going to move habeas corpus petitions from the Supreme Court to the Superior Court level. And so to make this kind of change, it requires a constitutional amendment. And this proposition is actually an initiative statute, so they're not permitted to make this kind of constitutional amendment in such a big change. And second, as Christine also mentioned, that the CDCR will be exempt from the APA, and that kind of eliminates the transparency and public participation in execution methods. And so that kind of eliminates some of the constitutional and legal protections that the APA provides for Eighth Amendment concerns.
Administrative Procedure Act.
Oh, I'm sorry, yes, Administrative Procedures Act. And so moving quickly on to the proponents and opponents arguments. Yes on 66 argues that it's going to save time and resources since it imposes a time frame in review of death penalty appeals, and it'll eliminate a lot of frivolous suits, and it'll also maintain public safety as the condemned inmates on death row will still stay on death row. And quickly moving on to no on 66, they would argue that it'll create a lot of hidden and litigation costs because of the constitutional issues that might arise from this proposition. And it'll also increase workloads for attorneys, as Christine mentioned, that attorneys may be required to take capital cases that are on the appointment list for the Supreme Court. And so many of these attorneys might not want to take these cases, so it'll increase the workload for those who are still on the list. And lastly, they also argue, the opponents of 66 argue that there are no safeguards for defendants who might be innocent. So thank you.
Thank you. Thank you. Okay. I'm going to answer this question very quickly. If both pass, which one supersedes the other? What happens when two propositions on the same topic pass is that a court needs to determine whether they are conflicting or complementary. If they are determined to be conflicting, the one with the greater percentage of the vote takes effect and the other one is invalidated. So if they both got more than 50%, whichever one got the higher amount of yes votes would take effect. These are probably going to be viewed as conflicting. Okay. Prop 62, what are the percentages of people on death row for first-degree murder? We don't know. Okay, we don't know. More 62. Okay. We already covered that. Okay, although people are sentenced to death, isn't it true that death penalties are rarely conducted in California, the last one being executed in 2004? Taking that into consideration, what form of punishment would exist if Prop 62 passes, I guess? Yeah, why don't we answer the question of if somebody's incarcerated for life without parole and they murder a prisoner or a guard, what happens at that point? Walk up to the mic.
So assault by a prisoner against another prisoner that results in death is actually one of the 6 ways that an individual in California can receive the death penalty. So theoretically, if you're in prison for life without parole and then you murder another prisoner in prison, you could then be converted to the death penalty. This Proposition 62 only repeals the death penalty for that first-degree murder.
Stay up there. If 62 passes, will existing death sentence inmates who have exhausted their appeals and other legal challenges to their conviction and sentence be granted new appeals and hearings after they transition to life without the possibility of parole?
It's unclear what the process will be to convert those sentences over to life without parole. It's probably more likely that if they've exhausted all appeals at that point, it will just be a converted sentence. But if they are in the middle of their appeals process, it's unclear what will happen to that process. The proposition does not say.
Okay. The rest of these are for Prop 66, but stay here because you never know if you might get one, although we're going to cull these a little bit just because we want to make sure everyone has a chance. For Proposition 66, did the reforms act retroactively, or will it only apply for new death penalty cases?
I believe it would be retroactively for all the appeals. So I think they'll be moving it to, they're expediting it.
To any cases that are currently pending?
Yes.
Okay. Will there be any cost savings with the passing of Proposition 66? And that is related to another question that says, if there are going to be more lawyers, how is that saving money? And it's a good question.
So both sides, well, the proponents argue that there will be cost savings based on the imposed 5-year time frame for review, and then also limiting some of the prison costs because of the procedure of moving some of the death row inmates to other prisons instead of having the maximum security for death row inmates. But then for proponents, they argue that there actually won't be any cost savings, so there's kind of offsetting of each other. The proponents argue that because of all these extra litigation, it probably won't have any cost savings, so it's to be determined if it passes.
And to add to that, with the attorneys, the proposition doesn't really provide like how they would come up with more money for having more attorneys, because the appointment is for inmates who are not able to afford an attorney. So it didn't really provide like where that money would come from.
Okay, so we have a few questions more about the attorneys, where they're going to come from, and requiring habeas corpus issue to be raised at the trial court level. And then my favorite question, what makes habeas so complicated? That is a mystery that we could do an entire class on what makes, and there is an entire class, we have one here. You could talk to our admissions department, we can get you in. and you can take the habeas class. Okay. So there is a question about where would the attorneys come from to represent the death row inmates, and how would the state pay? You've said we don't know how the state would pay. One of the issues is it is requiring a change in the criteria for who can be represented, and one of the things that the proposition does is attempt to lower the bar, right? I'll let you speak to that.
So I think it's, they're changing part of the government code to limit their defense experience isn't required for attorneys to take on these capital cases. So, I mean, that would probably bring an issue of effective counsel. So any attorneys who are on these lists for the Supreme Court they usually appoint these attorneys for defendants who can't afford an attorney, so they will be required to take on these cases even though they might not have the experience or the time to take on these cases.
Okay, thank you all very much. All right. So we're moving from death to plastic now. Plastic bags are our next topic. And we're going to start with Proposition 67 and then go to 65. Speaking to you about Prop 67 will be Scott Seward and Ryan Mahoney. And speaking to you about Proposition 65 will be Maral Farsi and Justin Hansen. And these are two more connected, interrelated measures, and even their slide is connected. I'll just...
Okay, can everybody hear me okay? Okay, so Proposition 67, also known as the California Plastic Bag Veto Referendum, is a referendum addressing California Senate Bill 270. A referendum is not an initiative. A referendum is different from an initiative in that a referendum is an opportunity for the voters to approve or reject a recently enacted law by the legislature. If approved, Proposition 67 will allow SB 270 to go into effect. If this happens, that will enact a prohibition on grocery stores, retail stores of over 10,000 square feet with a pharmacy, liquor stores, and convenience stores from providing consumers with single-use plastic carry-out bags at the point of sale. It will also establish standards for reusable plastic bags and create a certification system reusable bag manufacturers must follow in order for their bags to be sold within the state. Proposition 67 also mandates there be a 10-cent fee charged for every reusable bag or recyclable paper bag provided to a consumer at the point of sale at one of these regulated stores. Currently, 40% of Californians live in an area where there is a local ordinance that prohibits single-use plastic bags, and many of those local ordinances will not be affected by this statewide ban. However, Proposition 67 is written to preempt and then repeal and replace any local ordinance put into effect on or after September 1st, 2014. Now I'll turn it over to Scott.
So I'm going to discuss some of the public policy arguments for Proposition 67. First, proponents argue that Proposition 67 will reduce litter and waste and protect our ocean and wildlife. They argue that the current at-store recycling program only recycles about 3% of our plastic bags currently, and that the majority of them end up either in landfills or as litter. They further argue that plastic bags, by their properties, lend themselves to become litter. They're lightweight, they're easily blown around, and even when thrown out, they'll end up in streets or the environment. And finally, they argue that plastic bag bans have already been successful. 40% of the state already has local ordinances, and that SB 270 is actually heavily based on those local ordinances. Opponents argue that this is a hidden bag tax, and they argue that it's a tax because the state is mandating this 10-cent charge, and the opponents referred SB 270 to the people through Prop 67. They also argue that the 10 cents should, instead of going to retailers, go to an environmental fund. Finally, they argue that the plastic industry employs 300,000 people, and that there'd be job loss if plastic bag ban went into effect. Proposition 67 is a referendum, which can be confusing to voters because it is a challenge on existing law. In California, when you vote on a referendum, you are voting to approve the law, not the challenge. So if you want a statewide plastic bag ban, you should vote yes on 67 and no if you do not. Finally, there is another proposition, Proposition 65, on the ballot that could have an effect on 67. As mentioned previously, when there are complementary measures, they try and meld them, but if there are conflicting measures, the one with more votes will generally override part of, if not all, of the other measure. In this case, we're not sure whether 65 and 67 will be seen as complementary or conflicting. So to be safe, if you want a statewide plastic bag ban, we suggest that you vote yes on 67 and no on 65. Thank you.
All right, well, congrats everyone. You made it past the halfway point. My name is Justin Hanson and my partner is Morel Farsi, and we're going to talk to you about Prop 65, which, as you heard, is another carry-out bags initiative. Prop 65 says that if there is a statewide bag ban, such as the one proposed under Prop 67, all money generated from the ban will go to a new environmental fund, the Environmental Protection Enhancement Fund, or the EPEF, and the new fund will then use that money to make grants for environmental programs and causes such as recycling, drought mitigation, clean drinking water supplies, parks, litter removal, beach cleanup, and wildlife habitat restoration. The new fund will be under the already existing Wildlife Conservation Board, which today has a different function than what is being proposed under the measure. It is unclear whether the Wildlife Conservation Board has the resources to manage a grant-making program, such as the EPEF. To address how this fund can be established and administered by the Wildlife Conservation Board, the measure allots a $500,000 loan. Prop 65 is sponsored by the American Progressive Bag Alliance, which is an organization of out-of-state plastic bag manufacturers that opposes a bag ban in general and opposes Prop 67. But the plastic bag industry says that if a bag ban were to go into effect, that the money should go to the environment and not the stores. It is likely there are a lot of legal issues that will arise if this proposition passes, namely whether Prop 65 and 67 are conflicting or complementary, as Scott mentioned. Also, the legality of the loan, which would come from two previous ballot measures, the presence of a null and void clause hidden in the text of Prop 65, and a number of other provisions that are questionable. I now turn it over to Merle.
So just elaborating a little bit on this conflicting and competing measure issue, as Scott said earlier, if the courts deem this to be conflicting, they're going to look at the number of votes that each measure got, and then they're going to say this measure trumps the other one. However, if they're competing, what the courts will do is they'll take the provisions that are related or may conflict with each other, put them side by side, and then they're going to look at what the voters' intention was, right? So if voters looked at the ballot guide or the voter guide and they said they looked at the summary and they looked at the voter arguments and it was presented to them in a certain way, that's what the court is going to follow through on, and that's what's going to exist. So as Justin said, there's a flurry of legal issues related to this, and this is one of the main arguments that the opponents have against this. Another argument that exists out there by the proponents, which, by the way, there's only, the opponents. There's only one opponent, and it's one environmental group. And the reason for this is that they are really focusing all of their efforts on getting a yes vote on Proposition 67. They don't want to confuse voters by putting too much attention on Proposition 65. So one of the other things they mention is that if this model above us was to exist, let's say, for example, Proposition 65 failed. What happens to this 10-cent fee? It doesn't exist. So we have this structure, there's no ban, but then there's this grant-making agency that's just floating out there with this 10-cent fee that could actually potentially come from locality. So if, let's say, in the city of Sacramento, we have a ban on plastic bags, right? So city of Sacramento could voluntarily decide to send their money to this new grant-making agency. Let me talk about what the proponents are saying. As Justin said, it's the plastic bag manufacturers. So really what they're saying is that the state of California, in Sacramento, they failed to take into account what the consumers really wanted. So they say that Sacramento made these deals. It was the environmental groups with the grocers, and nobody thought about what the consumers wanted. Clearly, the consumers must want their monies to go to the environment. So one, we're giving them a choice if they want a bag ban or not, and two, we're giving them a choice of where they want to send their 10-cent fee. And they also argue that there's some environmental problems related to using these thicker reusable plastic bags, which that's just more plastic. But to Scott's point, as a counter to that, is the lightweight plastic is what causes all the problems in terms of physical pollution and marine pollution. And of course, they say that paper makes more greenhouse gases. So again, if you, just to emphasize this, this is going to be wrought with legal issues. So more likely than not, even if both measures pass, we will not see a plastic bag ban for a while until the courts resolve all of this.
Okay. Questions on 65 and 67? I know, that was very cheery, wasn't it? For a minute, when Justin said litter, I thought he said that we were trying to get rid of glitter, and I thought, oh, sad. Okay. Okay, thank you very much. All right. For Prop 67, are the 300,000 jobs in the plastic bag manufacturing industry, I assume, in California?
No, so, I'll let you, go ahead.
Yeah, no, they're not just located in California, no.
Okay. Is it correct that I would still pay 10 cents per bag even if I provide my own reusable bag? No. You bring your own bag, you pay no money. Bring your own bags, put them in your car. Okay. Proposition 65, does the merchant pay for the bag? So how would that work under 65?
So yes, the grocers would pay for the bag for themselves, and they would absorb the cost of any bags they provide to consumers. However, they can decide not to provide bags.
And follow-up is how much money is being collected from selling, well, this says single-use plastic bags, but we're selling single-use paper bags. How much money is being collected at this point? What are we talking about?
So I actually don't know the exact numbers, but I know that the environmental group told us that the price of I think it was a paper bag, right? It was anywhere between, depending on the purchasing volume that a particular grocer may have. So let's say Safeway can purchase a lot so they can get a better rate. What did they say, between like 9 to 15 cents?
Yes, they said that the bag cost, depending on the size of the order, is between that. And in a lot of these places, the bag revenue is not very much because in places like LA, most people have switched over to bringing in their bags every time, so they're not buying bags. And one thing I didn't mention earlier was there's a exemption from paying this fee for people who pay with a benefit from CalFresh or the California Supplemental Food Program. So retailers are still supplementing those customers. So even though a few customers are paying the fee, they kind of, in many ways, they almost even each other out from what we've seen in LA.
Good. This is a question for Prop 67. Is there any reverse commerce clause issues with outside, I'm going to interpret this one for you guys, with outside plastic manufacturers, especially with Prop 65, collecting a tax and funding in-state programs? So there's case law on this. Do you mind if I just briefly? Mind? Okay. So there is, here's the problem. One of the reasons that the legislature did what it did and allowed the grocers to keep the money was because if you collect money and then have it used for a general purpose, it is a tax. And then you do have to go through the process for approving a tax. So there is a potential, and this is one of the legal issues with Proposition 65, if we're all of a sudden taking the money and putting it towards environmental funds, it may be a tax, as opposed to if the people, the grocers keep the money and they're using it to buy the bags, it's not a tax, okay? So that's that one. Whoops, that's that one. And this one I really like. I'm going to let you guys answer it, and it's going to be the last one on this topic. Is this simply an attempt by the bag industry to confuse voters in order to undermine the bag law? If we want to screw the bag industry, how should I vote?
Vote yes on 67, no on 65. The answer to your question is yes.
Okay. Okay, thank you very much. Oh. I've got like too many microphones going on here. Okay, we're moving on to money. The topic is money, and we're going to hear about 53, which is going to be discussed by Justin Hansen and Gage Marchini. Then we're going to hear about Proposition 55, which will be Anam Hassan and Mallory Michael. And then we're going to hear about Proposition 56 from the Huynh sisters, Samantha and Stella. I feel like you should be a singing group. Okay, so Proposition 53.
Sorry you have to hear from me again. This will be the last time, I promise. All right, so once again, I'm Justin Hansen. This is my partner, Gage Martini. And we're going to talk to you about Prop 53, also known as the No Blank Checks Initiative. Prop 53 is a constitutional amendment. If it passes, it will amend the California Constitution. A yes vote for Prop 53 would require statewide voter approval for certain revenue bonds that exceed $2 billion. Revenue bonds are bonds that governments sell to fund projects and are repaid by the users of those projects. So a good example would be a toll bridge. As the users pay the fee for using the toll bridge, that money would go to the government, and then the government would pay back the bond. Revenue bonds, under current law, revenue bonds do not require voter approval regardless of the dollar amount involved. Prop 53 would apply to revenue bonds sold by the state or entities that the state is a part of, and projects funded, owned, or managed by the state. It would not apply to bonds sold by cities, counties, schools, community colleges, and special districts. A Stockton farmer, Dean Cortopazzi, and his wife are the main supporters of Prop 53. They have put over $4 million of their own money into it. Mr. Cortopazzi has a history of opposing Delta water conveyance projects in the Sacramento-San Joaquin Delta, and if Prop 53 passes, it would most likely present problems for Governor Braun's Delta Tunnel project.
Now, one of the issues with the language of the initiative is that it's unclear on the timing of the vote. that is the timing in the planning process of the proposed project, when it would need to be put forward to a statewide vote, as well as how that would affect the process, because you would need to wait until an election cycle for this to be put to a statewide vote. Additionally, it doesn't have any provisions to deal with what would happen if initially the project is estimated to be below the $2 billion threshold, but then for whatever aggravating circumstances is pushed above that threshold. It doesn't address that issue. The proponents argue that passing Proposition 53 would force the state to be more transparent and communicate more to the voters about the projects that it is proposing. This would be because they would have to get the voters on board with the projects in order to earn their approval on the ballot. Now, the opponents argue that this would affect local control of projects because while it would primarily apply to state entities who propose the projects, in one regards it would affect local control because JPAs, which are joint powers authorities that are commonly made up of local agencies, would also be subject to this statewide vote. And regardless of what the project would be for example, if it was a project that only benefited a local area, this project would still need to be voted on by everybody in the state, even though it would only benefit one portion and it would be paid back by only those local users of the project. Additionally, the opponents argue that there is no emergency exception to this voter approval requirement, and they argue that in certain circumstances, if there were an emergency that for whatever reason the repairs needed to be funded through revenue bond financing, there is no exception to expedite the vote or supersede the vote and allow them to go forward with reconstruction or whatever was necessary. However, the proponents do point out that revenue bond financing isn't typically the type of financing used to address those types of circumstances. Thank you.
Good evening, everyone. Thank you for joining us tonight. My name is Mallory, my partner is Anam, and we're going to be talking about Proposition 55. Before we do so, I'm going to give a brief history of Proposition 30. So Proposition 30 was passed in 2012. It raised the sales tax by 1/4 for 4 years, and it also increased the income taxes for a single filer, taxable income over $250,000, and that was increased for 7 years. And so Proposition 55 would extend only the income increase on taxes for 12 years. So the sales tax is going to expire. It also directs the money generated from this measure to go to the community colleges, as well as K through 12. It'll allow money to go to healthcare, and it would also allow money to go to the rainy day fund. We would like to note that the discretion is broad for the Director of Finance. So after the Director of Finance looks at the general funds, they determine how much money needs to be pulled from the funds that were generated from this measure. And then the remaining funds, 50% to $2 billion, will be used for healthcare. And the measure also allows money to be used for the rainy day funds with no formula.
Hello again. So proponents argue that schools would face large cuts without Proposition 30's extension of income taxes. They say without the extension, thousands of teachers would be laid off, classrooms would be overcrowded, and it would prevent students from getting access to teachers. Additionally, Proposition 55 improves access to health care. Currently, they argue California's health care is underfunded, ranking 48th in the nation. And Proposition 55 would generate at most $2 billion annually for healthcare funding in California. Opponents argue, on the other hand, that education and healthcare can be funded without extending Proposition 30's income taxes. California currently has a balanced budget. Therefore, there is no need for the income tax extension, especially since Proposition 30's income taxes still have a few more years to go. Thus, a yes vote would extend Proposition 30's income taxes to fund California's education and healthcare programs, whereas a no vote would allow Proposition 30's income taxes to sunset in 2019. Thank you.
Thank you. So we're going to talk about Proposition 56, which is the cigarette tax to fund healthcare, tobacco use prevention, research, and law enforcement. Prop 56 proposes to increase the state excise tax on a pack of cigarettes and other tobacco products by an additional $2. Currently, the state excise tax on a pack of cigarettes is 87 cents, and the tax on other tobacco products is $1.37. These taxes were set by statutes and two previous initiatives, Proposition 99 in 1988 and Proposition 10 in 1998. So Prop 6 will increase the state excise tax on a pack of cigarettes from 87 cents to $2.87 and $3.37 for other tobacco products. Prop 56 also expands the definition of other tobacco products to include electronic cigarettes. So the tax on other tobacco products will apply to e-cigarettes. So the tax on e-cigarettes will be $3.37. And this revenue from this tax will go to a fund used for spending on healthcare programs, tobacco prevention and control, UC physician training, dental disease programs, research, law enforcement, and administrative costs. So I'm going to talk about the fiscal impacts and then the proponents and opponents' arguments. For the tobacco tax is expected to raise about $800 million in revenue. California saw tax increases in tobacco taxes in Proposition 99 and Proposition 10, and with those propositions, they usually, in the first year, they had a large increase in revenue and tax revenue, but usually over a gradual number of years, the revenue would decline because usually smoking and buying tobacco products would decline as well because of the increase in taxes. And so moving on to the public policy considerations, the supporters of 56 argue that it's going to reduce youth smoking, as research shows from the U.S. Surgeon General that increase in tobacco taxes usually decreases tobacco use. Supporters also argue that it'll be paying for expensive health care. So an average cigarette pack would be about $6, and research shows that the healthcare costs for smoking is $9, about $9. And so with, as Stella said, the revenue for this tax will be going to some of the healthcare programs and dental disease programs to pay for these costs. And also it'll increase jobs because of these new programs in research and physician training. And so opponents of Proposition 56 argue that it'll be more money for special interests, and these special interests that opponents argue are usually the healthcare providers, hospitals, and insurance group. And so what they are arguing is that 82% of this tax revenue will be going to Medi-Cal reimbursements. However, hospitals and healthcare providers aren't required to take on new Medi-Cal patients or create new programs. And so they'll get the Medi-Cal reimbursements from the state, but then the extra 82% from this tax revenue will be going to the hospitals and healthcare providers, which they can technically pocket as they claim. And then they also argue that it'll be a waste of money and resources because the money can go to other more pressing issues like fighting crime, education, and fixing roads. Thanks.
Okay, thank you. Questions for 53, 55, or 56? I think we have some coming. They're taking a long time. Thank you. Don't hurt yourself. Oh, that's very cute. I will answer for them. Yes, they are twins. Are they twins? Okay. Yes, okay, so Proposition 53, wouldn't Proposition 53 slow all state projects needing bonds because of statewide election frequency?
Yes, it would. You would have to wait for a statewide election to determine whether or not the revenue bond financing would be approved for that project. So no matter where the project is in the planning phase, they would be uncertain as to whether or not they would be able to go forward and build the project until the next election, to where the voters could decide.
Okay, Proposition 55, we have quite a few for you. This one says, I have one friend, a couple. I'm glad you have a friend. Okay. Even a couple. Likely to be affected by 55, and they claim this is one more reason to leave California along with their taxes. Any idea of how many such people left California due to Proposition 30?
So evidence, that was loud. Evidence on this topic is not very clear. Some reports say that we have lost individuals, while other reports indicate that we have gained more individuals. So I'm not certain. Yeah.
I think around the time of Prop 30, there was a lot of talk that this would drive people out, and the actual statistics do not bear that out,
Yeah.
right?
Yeah.
So people talk.
Right.
Okay, for Prop 55, how difficult will it be for the legislature to shift the allocation of income tax to other non-school or non-rainy day purposes in the future?
So the discretion for the allocation for the funds is pretty prescriptive on that. It needs to go to community colleges K through 12 as well as healthcare. However, what can be done is pulling more money from the funds generated by this measure, and therefore allowing the general funds to be spread around in other ways, which is what Prop 30 did. Prop 55 is just saying that it needs to go to healthcare and it needs to go to the schools.
This one is about discretion and the finance director having the discretion. It's kind of related to what you were just saying. Does the public have any influence in determining how the discretion should be used?
No.
Okay. If we have a balanced budget, why do we need this tax extension? That's an existential question. I'm going to let you guys off the hook on that one. Okay. That's for voters to decide whether we need it or not. This is one about what personal income tax means if you're filing jointly. Would the $250,000 be per person or per household?
So that's a single filer. The numbers double for joint, so it'd be like 500,000.
Few, okay. I don't know, okay. Proposition 53. Would Proposition 53 possibly get in the way of high-speed rail?
Yes, it would, because the high-speed rail project is now expected to cost, I've seen estimates that say like 80 billion, 70 billion, but so they're going to need more funding to go forward with the project.
Okay, stay up here. The Delta Tunnel project has no review mechanism by the people, so doesn't Proposition 53 give the people a say on how or if it should be paid for by revenue bonds?
I think what the question is, as it is now, Cal Water Fix, or the Delta Tunnels project, does not have to go to voters for approval. And so the answer is yes, if Proposition 53 passes, Cal Water Fix is estimated to be over $2 billion. So it would have to go to the voters for approval, as would all state projects funded by revenue bonds in excess of $2 billion.
Okay. Prop 56. Please give your opinion on the tax grab argument by those opposed to 56.
Our personal opinion?
Your educated opinion. Hey, I was going to say that. All right.
Are you talking about the special interest?
Yes.
Oh, I mean, technically, yes, the 82% will be going towards Medi-Cal programs and hospitals and healthcare providers. They aren't required to take any new patients. So, yes, like, it's somewhat true. But if you like really think about how Medi-Cal is administered and how it's funded, the state of Medi-Cal, maybe they want more money or need more money. That's my opinion.
Okay. There are two more that are sort of related to this about the 82% given to the private enterprise. How can it be pocketed? Where is the taxpayer discretion? How do we know if the tax money really goes to research and not into the pockets? This is the general question.
I mean, the proposition lays out how it's all split up from the fund. So the 82% would go to healthcare programs, and there's like a certain percentage goes to research, and it's supposed to go. It's a breakdown percentage in terms of how much money goes to each program that the prop asked for.
I think probably the short answer also is there is some oversight, right? This is going through the finance director. Okay. The government, don't worry. Okay, final question on this one. Who is subsidizing no on 56?
The tobacco companies and e-cigarettes and e-cigarette companies.
Yeah, I will underscore, this is the big difference between what we have now and what Prop 56 does in terms of taxing, in terms of the excise tax on tobacco, is that it sweeps in the e-cigarettes, which right now are not subject to an excise tax. They're only subject to sales tax. So now, question whether the legislature could also, do that, but it's a tax and we need to think about what we want, and e-cigarettes is big. If you read the report, e-cigarettes is huge. Okay. I know, that was bad. I know, I shouldn't have said that. All right, it's getting late. We're moving on. Okay, we're down to our last four initiatives. We're going to try to go through these next two, I'm looking at you two, very quickly, because we want to get to the, we're now talking about health, and then we're talking about adult recreation. And we want to get to adult recreation, so Prop 52 is Brittany Bersati and Jamie Taylor. We're going to talk about the Medi-Cal hospital fees. And then 61 is prescription drug pricing, and that will be Mallory, Michael, and Brittany again. So.
So I'm going to be hanging out with you guys for a while, and I need to talk really fast, so keep up. Hi, I'm Brittany. So Prop 52 deals with the hospital quality assurance fee. So to get back to a little bit about the question about Medi-Cal funding for Prop 56, hospitals take a pretty substantial cut when they treat Medi-Cal patients. And what this fee program does is it collects money from the hospitals, it gets matching federal funds, and then we pay money back to the hospitals. And so they can recoup 40% of the losses that they take when treating Medi-Cal patients. And currently there's 1/3 of the state on Medi-Cal. That's 13 million people, so that's pretty substantial. This program's been around for a few years. Every time the legislature has needed to renew it or it will expire, it has been renewed. And right now it's currently set to sunset in January 1 of 2018. Basically what this initiative does, it creates a constitutional amendment, so it would take 2/3 of majority in the legislature to amend the program. It also creates a trust fund, which is a type of special fund, which makes it harder for the legislature to divert the funds, which has happened one time before during the budget crisis. And basically, but it does still give some latitude for DHCS and or the legislature to adjust the methodology for the fee program if there is a change in federal law. And just to put on your radar, in May, the federal government did issue new regulations which could affect the methodology, but everyone we've spoken to seems to believe that DHCS, the Department of Healthcare Services, can adjust the program to comply with those new federal laws.
And as far as the support and opposition, the proponents argue that this is a required, it helps to generate revenue that is medically necessary to meet Medi-Cal patients' needs and services. As Brittany mentioned, the hospitals take a very big cut. Since 2009, they've invested or incurred about a $40 billion loss, and this represents, this program has represented in that time frame a mitigation of about 18 billion of that 40 billion. It's definitely a necessity in order to leverage federal funds. So hospitals assess themselves, they match that with federal dollars, and they believe that this is extremely important for California in terms of leveraging those federal funds. So doing so in perpetuity kind of takes the pressure off from having to come back to the legislature every 2 years, every couple of years, every year. And it doesn't, in their opinion, the California Hospitals Association feels that by coming back to the table, it invites politics to erode their intent, which is to meet the needs of Medi-Cal patients, the most vulnerable in our state. And as Brittany also mentioned, that is about 1 out of 3 persons, 13 million people, and 7 million of which are children, so our most vulnerable. It also, as Brittany mentioned, prohibits the legislature from diverting those funds. Back in 2011, they did so, and so it secures that funding source in a lockbox or a trust fund to be utilized only for that specific use. So they are very much counting on you, the voter, to give that fund its secure use as a trust fund. And the opposition is very small. In fact, it's just one group in terms of being an organized group. There are individual contributors who have given money to this no on Prop 52, but for the most part, a high amount of funding has come from SEIU, United Healthcare Workers, but they have actually in the last month removed their opposition. Initially, they were against the legislature, sort of stepping away and letting you, the voter, give this program perpetuity status. And they like the idea, SEIU likes the idea of coming back to the table. It promotes a collaborative process, makes the program flexible and up to date. If there are problems with the methodology, with the federal requirements, they feel like as stakeholders they can come to the table and be heard by the legislature, and this sort of takes away the power of the legislature, makes them sit on their hand, and they aren't supportive of it, but they again have removed their opposition. A yes vote means that you support extending this program and removing the sunset. A no vote means that you would probably most likely see this again happen in the legislature because of the federal funding mechanism that needs to be matched in order to meet these needs. Thank you.
All right, now on to Prop 61. I'm going to start talking while Mallory joins me. She's here, just like that, magic. Okay, so Prop 61 is state prescription drug prices. Basically, we all know prescription prices have been growing, and this currently the state, for all of its programs, has a few ways to negotiate prices with the VA. Sorry about that. The VA is estimated to have the lowest prices, which this proposition tries to lock in for state funding. However, it's unknown whether or not the VA is getting lower prices than the state officially, because they have confidential prices that they receive through supplemental rebates, and also some of our state agencies negotiate together and get those additional discounts in the form of supplemental rebates. And a few agencies have actually tried to find out the exact confidential prices from the VA, but have been unable to do so. So the way that the proponents of this bill would like to solve this problem is to bind the amount that the state can spend on prescription drugs. It does nothing to make sure that the drug companies will comply with the price that the state is, the cap that the state can pay. In the event that the drug manufacturers don't decide to take a profit cut for whatever reason, there will be a possible preemption issue. And basically what that means is under federal law, all the Medi-Cal programs that will be affected by this proposition, because they are the ultimate payer for medications, will be required to offer all medications that are licensed and approved by the FDA, regardless of whether or not the drug manufacturers comply. So there's a very high possibility that there will be litigation on that issue. And I think that's it, yeah.
Okay, proponents of this measure are upset with the high prices of prescription drugs, so that's the need for the bill. And they also want to lock in and require the state to get the lowest prices for the prescription drugs. Opponents have a lot of fears about this measure because the impact is unknown because of the different responses that the pharmaceutical company may do. So opponents fear that it may raise prices for veterans. So this is evidenced by, in the early 1990s, Congress tried to match the Medicaid with the VA prices, and then the next year they repealed it because there was some impact to the VAs. It raised their prices. Opponents also fear that it may reduce patient access. So currently what happens, state agencies will negotiate with the companies and they would put the prescription on a preferred list. In doing so, they take out the admin procedures that are required. So opponents fear that this would mess up that system and mess up the preferred list. And as Brittany mentioned, there would be possible lawsuits, and that's what opponents are saying as well. Thank you.
Yeah, questions?
Okay. Questions on 52 or 61? Here's one. Proposition 52 and other constitutional amendment initiatives. Is a constitutional amendment a good way to accomplish this task? Why not defer to the legislature if it has already been extending the measure, the bill? Go ahead.
I mean, it's really up to you. You have the opportunity to extend it if you feel that politics plays into the decision-making for the legislature, and that they might divert the funds. If you feel that they will continue to look at it on a merit-based, case-by-case opportunity in the legislature, then I would say vote no and give the legislature an opportunity to do it. They have continuously supported it unanimously and most likely will continue to do so.
And I will just make a personal pitch. We have a very long Constitution. I just want to say that. We don't need to be adding more to it. That's a personal preference. If you sit down and try to read it, make sure you have a cup of coffee. Okay. And a lot of time. Okay, who is paying for the ads against Prop 61?
Pharmaceutical companies. California Medical Association, yeah.
Oh gosh, I love this one. Okay, Bernie Sanders says vote yes on 61. Shouldn't I listen to him?
Well, you all, as informed voters, get the choice of picking who you want to listen to or not. I haven't questioned Mr. Sanders on his personal viewpoints on why he would support it, but I think all of his comments on the issue have been that prescription drug prices are a problem that are costing our country more money, and this is a possible solution to that, maybe not necessarily the best.
Stay up there, 61. Can a drug company just deny a medication if California refuses to pay the cost? Can a drug company refuse? If California says we're only paying this much, would the pharmaceutical companies be able to say, then you can't have the medicine?
Right. There's nothing that binds the pharmaceutical companies to sell at the price that the state is required to purchase from. So there's, yeah.
Yeah, and part of the reason the VA gets so low prices is because they only offer a very select few medications, which is because there's a increased competition, they're able to get the prices at a lower rate. However, if it is a Medi-Cal program, the state will have to negotiate and get a price because they are required to offer the medication.
And one more note, sorry. This measure only applies to the prescriptions that the VA purchases. So if the state's purchasing a medication that the VA doesn't purchase, then they're not required or bound by anything.
Okay, I'm having trouble reading this question. I'm going to try. A law stipulates that hospitals must treat Medi-Cal patients, otherwise they are they get a huge fine. So they need this law, otherwise hospitals will take a huge hit without reimbursement. This is only renewing this in effect. This is 52.
Is that a question or a
I
statement?
think it's a statement. I think it's a statement. I think we will confirm that yes, Proposition 52 is enacting into our Constitution something that the legislature has been enacting to have this Medi-Cal reimbursement. It's not a new concept. It's not a new thing. It's enshrining in the Constitution a legislative act that has been happening and that is part of a larger mechanism with federal reimbursements and hospital fees and state money moving. So the question really for Prop 52 is, do you want to keep letting the legislature do what they've been doing, working with the federal government, having the flexibility to make those changes when federal regulations change, or do you want to say we're going to lock in what we're doing into the Constitution, making it much more difficult for the legislature to change it if it needs to be changed? But it's true that this is an existing program, that there are laws that say we have to treat Medi-Cal, and there are mechanisms in place to reimburse hospitals for a percentage of that. As Jamie indicated, they're only getting reimbursed a small amount compared to what they are going out in Medi-Cal patient treatments. Does that help?
It does, and just to clarify, I believe under the law, if someone comes to an emergency room and is in like a life-threatening condition, you have to treat them regardless of whether they're Medi-Cal or not. So anybody who comes with an emergency condition would need to be treated.
Correct. Someone wants to follow up?
Mm-hmm.
Yeah.
Yeah.
Well, it has to go through either through the legislature or through the initiative process. And that's the issue. The only issue is, should we be doing it through the initiative process and a constitutional amendment, or should we keep doing it through the legislative process? I don't think there's any question that it's going to keep happening. It has to happen, as you point out. Okay. Thank you very much for that, everyone. And thank you, sir. Okay, I think we are finally closing in on our last two, and I know we're a little over time. We understand if you have to leave, but we saved the exciting stuff for last, just to keep everyone captive. Proposition 60, we will have Christine Mahakian and Melody Aguilar talking about Proposition 60, and then we will have Brian Perino and Gage Marchini talking about Proposition 64, and I will click. Oh, you got it. All right. I went too far then. You got it back. Okay. Oh, no. Can we see it? We can't see it.
Okay, hi everyone. My name's Christine, and my partner Melody and I are going to talk to you about Proposition 60, which is also known as the California Safer Sets in the Adult Film Industry Act. There are three major changes that will come if Proposition 60 would pass. So the first would be that it would add a provision in the California Labor Code that would require the use of condoms during the filming of set scenes. It would also require adult film producers to provide condoms to adult film performers and ensure that performers are using them. Condoms would not have to be visible in the films distributed to consumers. However, there's going to be a presumption that they produced the film in violation of the new requirements. So the adult film producer would have to be able to prove that the performers actually did use condoms. The second change would require adult film producers to be licensed by the State Division of Occupational Safety and Health, which is known as Cal-OSHA. These licenses would be required to be renewed every 2 years. Adult film producers would have to notify Cal-OSHA whenever they're going to start producing a new film. The adult film producers would fill out an application, and then they would have to pay a fee for these licenses to Cal-OSHA, which would go to their use in administering these new requirements. Adult film producers would also be required to pay for the costs of STI, preventative vaccinations, STI testing, as well as medical exams for adult film performers. And adult film producers would also be required to keep records showing that they complied with the new requirements of Proposition 60. And finally, Proposition 60 would allow individuals to bring lawsuits on violations of these new requirements. So any California resident or any adult film performer would be able to go to Cal-OSHA and request them to address any adult film workplace violations. If Cal-OSHA did not take any form of action within 20 days of receiving that request, then the individual would be able to file a civil suit against the adult film producer. If the individual would prevail, the person would be able to recover legal costs as well as 25% of any penalties paid by the defendant in such a lawsuit, and the rest would go to the state. Civil suits would not apply to adult film performers or employees, so long as those individuals don't have a financial interest in the adult film and are not producers of the film. So now I'm going to hand it over to Melody, who's going to talk to you about the pros and cons.
Hello, everyone. Okay, so I'm going to go briefly over the proponents' arguments for Proposition 60, and that's that although condoms are currently required as of now by Cal-OSHA and their regulations, there's this really big problem with enforcement and the agencies not complying with the condom usage in current adult films. There's a couple of reasons for this, but the main one is that the adult film producers essentially lose profits by including condoms within the adult films because it is not considered the fantasy that the viewer would like to see. So the problem ultimately is the lack of enforcement ability. So to address this, Proposition 60 would make the attempt to increase accountability for the adult film industry and the producers mostly by requiring them to pay for the HIV, STI testing for their performers, as well as letting them know that they're going to be subject to these lawsuits and fines if they do not abide by the regulations. So that ties into the opponents' arguments, which two of the main opponents are the California Democratic Party as well as the California Republican Party, and they fear that because of this lawsuit addition that is going to be a possibility for any California resident to file a lawsuit against the producer who is in violation by not abiding by the regulations, that they will engage in what they call a lawsuit bonanza, and ultimately the administrative court procedures will go up the roof and will impact court procedures and the administrative costs overall. So that is a really big concern, as well as the fact that the lawsuits and the
profits that will decrease by supposedly including condoms in these films will drive the adult film industry out of state into a state that doesn't have these regulations, so they don't have to abide by the regulations, and or that they will go through the black market or they will go underground, and then they still won't have to abide by the regulations, or the adult film performers will be in a more vulnerable state by not having any sort of health requirements that are going to be met. And the final concern that I will touch on, there are more that I would encourage you to read about, but the final one is this privacy concern, this idea that if we are engaging in lawsuits, we will have to require the adult film producers to give us names, addresses, as well as health history of the performers, especially in the cases in which the adult producer is actually a performer filming the films within their households and being a producer and a performer at the same time. So that is a really big concern, is the privacy of having to disclose the medical history potentially, as well as names and addresses. And that is all for us. Thank you.
Thank you.
Oh, okay, finally, what everyone, I'm assuming, has come here to talk about marijuana. Prop 64, the Adult Use of Marijuana Act. So I will talk about the federal interaction, current state law, and tax revenue breakdown, and then Gage will go into the proponent and opponent arguments. So I'll talk briefly about the Controlled Substance Act, but if you want to read those 8 priorities, we will get into that next. The Controlled Substance Act was signed by President Nixon in 1970, and it listed marijuana as a Schedule I substance. A Schedule I drug means that the government does not recognize any medical benefits, and the drug has a likelihood of addiction. So anyone who smokes marijuana, whether they are living in a state that has legalized it or whether they have a proper a medical marijuana ID card, is technically in violation of federal law. So the Department of Justice outlined 8 enforcement priorities in a memo by Deputy Attorney General, James Cole, in August 2013, known as the Cole Memo. And these are the 8 priorities in that memo. And so that is understood to allow states to legalize marijuana so long as the state laws adequately address the goal of preventing 8 of those listed factors. So for California, the state law in 2010, Governor Arnold Schwarzenegger signed SB 1449, which downgraded possession of under an ounce of marijuana to an infraction from a misdemeanor. So therefore, an infraction would not go on a person's record. It's currently illegal for California residents to grow marijuana for non-medical purposes. Drivers with marijuana found in their vehicle are subject to a $100 infraction fine so long as the amount of marijuana is less than 1 ounce. So for the state medical marijuana law, in 2015, the California legislature passed what's known as the Medical Marijuana Regulation and Safety Act, and Prop 64 takes that regulatory structure and applies it to recreational marijuana. And so Prop 64 applies to individuals who are over the age of 21 and allows them to possess up to 28.5 grams of marijuana. It imposes a 15% excise tax on the marijuana. It would allow individuals to grow up to 6 plants per single family residence. It would allow local governments to impose their own sales tax on recreational marijuana, as well as completely ban it. It would create the California Marijuana Tax Fund to collect all tax revenue from the sales of marijuana. And so that would be the first priorities, 1 through 5 right there. Those are specific dollar amounts that would go directly to those programs. Then after the money is taken from the fund, the remaining funds will be dispersed with 60% going to youth drug prevention, treatment, and education, 20% environmental restoration projects that have been negatively impacted by illegal marijuana growing, and 20% would go to local law enforcement for grants to aid and costs associated with the implementation of Prop 64. Now that last 20% there, if a local government did ban the cultivation and sale of marijuana in their community or in their jurisdiction, they would not be eligible for that 20%. and then Gage will talk about the proponents and opponents' arguments.
So one of the first issues is issues with access. Now, the proponents of the initiative point out that this would be limited, access would be limited, similar to alcohol. You would only be able to possess marijuana if you were over 21, and we would require licenses to sell marijuana, as well as for marijuana to be consumed in public. It would be limited to venues that had applied and received a license for that specific purpose. Also, licenses for alcohol and marijuana would not be allowed for the same place. So one store could not sell both alcohol and marijuana. The opponents argue that in Colorado, after legalization, they saw an increase in black market activity related to marijuana. And the opponents also point out that there are no restrictions for how many marijuana retail locations could be licensed in one neighborhood, and they argue that this would disproportionately affect underprivileged communities. The proponents claim that this is the toughest in the nation protections for children in regards to legalization of marijuana. And to support this, they point out that there would be stores would not be allowed to be near schools, and there would also be limitations on possession and consumption around schools, and some advertising restrictions that I'll speak of in a moment. However, the opponents point out that the stores are only limited to 600 feet, that they only have to be 600 feet to a school, and that the school restriction doesn't apply to growing plants in personal residences if you live near a school. Now, mind you, that would have to be in the backyard. It wouldn't be something that would be in somebody's front yard across the street from a school. Now, with advertising, the opponents have raised concerns about the advertising, claiming that it would be able to be advertised to children or on major networks during major events. However, there are restrictions on advertising to children that would not be allowed under Proposition 64. And one of the main takeaways is so long as this is a federally listed Schedule I substance, advertising would be illegal under federal law, and this Proposition 64 would do nothing to affect federal law, only state law. Now, finally, the opponents have pointed out that there is no specified DUI standard for marijuana. However, this was intentional on behalf of the drafters, and they have allocated funds to researching and finding an appropriate method of determining how different levels of THC in your blood affect and impair your ability to drive. Thank you.
Okay. Questions on 60 and 64? Lots of questions on 60 and 64. We're going to try to process all of them. Oh, there's more and more and more. Jess, bring me those to get started. And you can go back. Okay. Oh, that's good. Okay. This is for 64. Would the no smoking ban for restaurants and bars apply to smoking marijuana, or is that a separate issue?
So locations would have to apply for a special permit or license to be a venue where marijuana consumption is permitted, but only with that license.
Prop 60. This question is, I've heard opponents of this proposition use the argument that taxpayers must fund the purchase of condoms. Is this true? No.
No.
No, thank you. No. No, okay. Oh, this is an interesting one. 64. How does legalization influence residential users if neighbors protest the pungent smell? Anybody? Anybody want that? I don't think it influences nuisance law. So I suppose you could still have a nuisance action. I'm just going to go, it would be a different, but I think it would not impact nuisance law at all. And if if it were that pungent, you could probably file a lawsuit. Okay. Prop 64. Do you know the impact of the passage of Prop 64 on employees that are subject to random drug testing? For example, I smoked weed on Tuesday night and tested Wednesday afternoon. We don't want to know.
So with regards to testing for employment, that would still be eligible. So for instance, if you were a truck driver or like if obviously a doctor can't practice while high, and so that in situations like that, they could still test for that, yes.
Okay, stay there. How will Prop 64 ensure cannabis agricultural development does not affect watershed pollution, major water diversion?
Well, actually, one portion of the initiative directs a lot of the funds to go to environmental restoration for damage that has been done by illegal cultivation of marijuana. And what was the rest of the question? I'm sorry.
It was about watershed diversion. It went away.
Well, and the initiative itself doesn't affect the water code, so still they would be subject, like other agricultural interests, to securing their own water supply. But a part of it does go to a part of the funds do go to environmental restoration efforts. Did that answer the question?
I hope so. Are the licenses for sales and for use in a business different? So, this is going to Prop 64, I believe, and the question is, are there two different licenses, one for selling marijuana and one for use of marijuana? I think that's
You wouldn't need a license for use. You would need a license to be a retailer, someone who sold marijuana, a store who sold marijuana. You wouldn't need to obtain a license for personal use anymore, like you would currently need to obtain a medical marijuana card to use marijuana for medical purposes. Now it would be legal for recreational purposes for anyone over the age of 21, subject to all the restrictions on where and how much.
And this is a good segue because the question is, won't the passage of Proposition 64 negatively affect medical marijuana patients with the increased costs?
So the 15% excise tax would apply to medical marijuana. However, the sales tax, the medical marijuana would be exempt from the sales tax. So any taxing that was sales tax implied by the state or local government would not apply to medical marijuana.
Okay, we're going to do a couple of 60s just to mix it up and give you guys a breather. This is one from a live stream viewer. Yay. We have one, and they got a question through. Excellent job. Okay. Do HIPAA laws protect adult film actors and producers from discovering and publicizing their medical records? This is the privacy question.
Yes. Yes, they do.
Yeah, and this is a big concern, right? Because the HIPAA laws do protect medical records of everyone, and so the question is how that would be worked out if there were going to be these private citizen lawsuits going after the producers.
Yeah, I mean, ultimately, it would be the name and the address. If the performer is a producer, that would have to be disclosed, but it would be for civil litigation purposes. I mean, any more disclosure than that would not be occurring.
And Prop 60, stay up here. Does this proposition include people making porn in their home with the intention of it going online, or only professional producers?
It depends if they're profiting off of it. So if the performers are distributing their films online and profiting from it as the producers themselves and take that title, then this would apply to them, which is where the civil lawsuit issue comes into play, because then they would have to disclose their name and their address for civil litigation purposes. But if they're recording within their homes and then they have a producer that they send the films to, that would be the producer that would be subject to litigation and have to abide by the regulations.
Okay. 64 again. We've got some really good questions. So how do other states deal with the DUI, the driving while impaired issue?
Yes, so some other states do have it's referred to as a per se standard. In Colorado, it's 5 nanograms per milliliter of blood. But the AAA just came out with a study about a month ago that said a per state standard doesn't really determine whether someone is actually impaired while driving. And so it's not really relatable to, with the 0.08 for alcohol, everyone is too impaired to drive. With marijuana, people's bodies metastasize it differently. So that's why it was specifically chosen to try to develop a further test to test for DUIs.
Okay, could counties limit the number of stores in their county? And what's the effect on unincorporated counties? If you know.
I do not know the unincorporated counties question, the answer to that question, but counties can pass their own county ordinances limiting retail locations of marijuana, yes.
Okay, what safeguards are in place to protect small farmers from large companies that would begin investing or growing and selling marijuana themselves?
Specifically, I believe what the question is referring to is there's a Class 5 license, which applies to large-scale license, and so those licenses wouldn't be available for 5 years until 2023. And then to protect against monopoly, a license has to be granted every year. It only lasts for 1 year, and then it has to be reapplied for again. There's no automatic guarantee that that license is granted if it was granted before. And so there are specific questions that the regulator has to ask when granting that license, and one of the first questions asked is, would granting this license create a monopoly? And so that's how there are specific provisions to protect against a monopoly forming. And because a Class 5 license is available in 5 years, there's no guarantee that any actually have to be issued.
Just one quick follow-up on that. So put another way, that is one of the other arguments, is that provision, that 5-year provision, is a way to keep large tobacco from coming in immediately and controlling the marijuana development from the get-go. There would be a 5-year period before any large-scale production like that would be permitted.
Okay, while you're here, I understand that any proposition passed by the electorate cannot be changed by the state legislature. If this is so, is there wording in Prop 64 to allow for changes as needed if this is voted into law?
Yes, there is. There are specific provisions that would allow the legislature by a simple majority to change the law, so long as it conforms with the purpose of eliminating the black market. There's several purposes outlined in the bill, and so the legislature is free to change it so long as those changes conform with the initiative's intended purpose.
Okay, Prop 60, I know this is the question that you've been waiting for. Would condoms be required for non-penetrative sex scenes, oral sex scenes, and would female condoms meet the requirements?
Okay, so the condom usage would only be required for any vaginal and anal penetration by a penis. So vaginal sex is not included in the language, and that is one of the personal critiques that I had when I read it, because if your goal is to protect against STIs and you're not requiring female condoms for vaginal sex, then you're kind of leaving a group of folks out. So that is a very good question. I appreciate that.
I was just identifying the group that was being left out. Women. Okay. Okay. I think we talked about 64 regarding out-of-state corporations owning and growing. Did you touch on that? Not yet. Okay. What does Prop 64 provide regarding out-of-state corporations owning, growing, and distribution operations? Is there any prohibition on that? Did you already answer that?
They would still be subject to the same limitations of obtaining the same licenses and the same limitations on large-scale involvement in the California market.
And also the businesses that are currently, let's say, selling medical marijuana and they're complying with state law, if they apply for a license, they would be given priority for that license as well.
Okay, 64, does this measure permanently lock in high levels of funding for state fish and wildlife and state parks? Is that on your slide? Does it lock in any money for them?
No, it doesn't. It does have money for environmental restorations, but I believe that's temporary. Is that permanent as well? But that, I don't think that's specifically locked in for anyone.
Okay. Okay. I think we're going to pick one more on each of these, and then we're going to be done. So Prop 60. Would this be considered a restriction on artistic freedom, and will the funds from fines be used for STI prevention education? That's a two-part question.
So that is the argument on behalf of the adult film performers, the ones that are against it, because I think the adult film performers are kind of split in the middle depending on whether or not they've had bad experiences. But the ones that are for expression and personal freedom, from what I can tell you and from you can read from the report, is that they are not comfortable with having to use condoms because of the length of the films. They just feel that it's uncomfortable, and they have the right to choose whether or not they should be, between them and the partner, that they should have the right to choose whether or not they want to use these condoms. And the money, I mean, some of the regulations that will be in place is that they will have to require training. The producers will have to require the training for the performers in regards to adult health and safety, if that's what the question is referring to. And they do have to have like signs within their filming place of, we require condoms to be used at this film site, and that kind of education. So I hope that answers the question.
Thank you. Okay, final question on 64. I'm taking two questions and making them one. The question is, if you can only possess 28.5 grams, how does this relate to the 6 plants when each plant can provide or can produce up to a pound of weed buds? That sounds like someone with insider knowledge. And the follow-up is, if you do violate that limitation, what is the penalty for violating the allowed amounts? So
with regards to the production of the 6 plants, so if the 6 plants did produce more than 28.5 grams, you would still be able to keep that marijuana. However, you have to keep it in your household. So there's some states have whether how many plants could be actually mature or not. This one is not. You can grow 6 plants. They could all be mature. Any marijuana that is produced in excess of 28.5 grams has to be kept inside the home.
And what are the violations? What are the penalties for violating?
Yeah, it'd be subject to a $500 fine.
Okay. Thank you all very much. I'm sorry we went late. I want to thank everyone very much for coming out. I hope you got some information and some education. And please, please, absentee vote, in-person vote, but do vote November 8th. Thank you very much.